best information you're going to get on the basics of estate planning and what you should consider when you're doing it. A lot of people think that they've got, you know, my will and everything's tickety-boo, but Gary's going to bring up some issues that you may want to consider and maybe retweaking your estate plan. So Gary is one of many of the people that I work with. We also have in the room today our financial planner, Craig Merriam.
Hello.
And he may have worked with some of you on doing retirement plans. And he's another one of our specialists that I work with in our team. So we're going to try to keep it fun today. I know estate plan's not the most exciting topic to talk, but Gary always makes it fun. And we're recording it today because I want to get this information to a number of my clients. I have clients outside Canada, I have clients all across Canada. I think this is a great way to get Gary in front of them, because I think Gary's the best that we have. So without any further ado, Gary.
Thank you very much.
And ask questions, by the way, along the way. Even though it's being recorded, we can edit it, so feel free not to be shy.
Yes, don't be shy. Basically what I do is do these types of events where part of my job is to impart the knowledge that we have out there for estate planning. So I'm going to give you some options or strategies that to this point you may not be aware of, and I'll talk specifically about the good points and the bad points of each. We'll also use some real life examples of what to watch for. So a lot of times what people might think is just something simple and they don't need to worry about it. Really that's the thing that might come up and cause most grief. As just a short definition of estate planning, what is it? In fact, they refer here to a blueprint, but basically it's a review of your current assets. It's a look at your circumstances, your family, your wishes, your desires, who you want to benefit when you pass away. It also includes other things like planning for perhaps potential incompetence down the road. So for example, if I have a stroke and I've survived, then there's some things that we're going to discuss away today that will deal with those specific things as well. Why would you want to plan in the first place? All kinds of reasons, everything from saving tax to organizing and simplifying your affairs, to actually protecting your assets or protecting your loved ones. And really, it's these 2 points here that you should be concerned about. And some of the real life examples or stories that I want to chat about today, it speaks to this, because you're not doing this for you. Particularly for the estate planning piece, you're going to be dead and gone, and I haven't had anyone come back yet from the great beyond to say, if I had known, I would have done this. But you're doing this for your loved ones, so it's not something that you're going to see too much benefit from, but you want to make certain that the things that you're aware of and put in place actually does this. So a lot of people are concerned with, how do I save tax? A lot of people are concerned with, well, I've got one of my kids that perhaps needs a little help with managing money, or it might be, you know, I love my kids dearly, but you know, number 2 son is on his 4th wife, and I'm worried that that means that he's not going to be able to retain his assets. So all those kinds of things we're going to chat about today. There's 7 actual strategies that we commonly talk about here in Nova Scotia, and while most of the discussion for your purposes today will probably well be, well, I'm in Nova Scotia and I want to know what the things are here. We're going to try and be a little generic because in Pamela's instance, she's got clients right across the country. But the first, which is the most horrible thing you could do, is do nothing. In fact, we have had clients say to us, I don't need a will, I don't need to be concerned with how my assets are registered. I'm going to give you just a quick example, and this is a real life scenario that happened in Newfoundland last year. There was a gentleman and his wife. He had always taken the approach that, well, I've got everything in joint names between my wife and I, therefore I don't have to go out and spend thousands of dollars on a lawyer to do wills. I don't need a will right yet. When I die, then my wife or my widow can go see the lawyer and make some arrangements and get things corrected. But right for now, I'm not going to spend a big fortune on getting a will drawn up. The problem with that approach came back in this way. What happened last year, and I'll give you a little background first with this couple. They were in their 60s. They were married for a second time. They each had children. She had a daughter from a previous relationship. He had 3 adult sons from a previous relationship, and they had no children together. So what happened, they were in a huge car accident, and they were both killed. And what happened was one of the 3 boys came in to see the branch in St. John's, and he had the questions, well, what happens now? my dad and his wife have passed away, and they said, at least 2 or 3 sides to every story, but according to the son, the bulk of the wealth within the couple came from the husband or the father when he married his wife. And so he thought, this was the son of the dad, that perhaps the division of the assets would go more towards the 3 boys than it would the daughter of the lady as well. So we said, no, it doesn't work that way. And he said, well, maybe it goes this way then. We've got 4 kids. Maybe all 4 kids will share equally in the estates that are there. And we said, no, it doesn't go that way. And he said, well, maybe where there's dad's side and his wife's side, maybe they simply cut it down the middle. So us 3 boys will share 1/2 of the estate, and the stepdaughter, or stepsister in his instance, will get the other half. No, it doesn't work that way. So he was getting pretty distraught at this point, and when we explained to him how the rules work, he was very, very upset. What happens in an instance like the one in Newfoundland, and it's the same here in Nova Scotia, is that when Mr. and Mrs. are killed in a car accident, and it's indeterminable as to who has died first, the youngest is deemed to have survived the oldest. So in this particular instance, the Mrs. was deemed to have survived the Mr. And under the intestacy rules, because they had no will, everything then was deemed to be owned by her estate, nothing in his estate. And under the intestacy rules, everything ended up owing to the daughter, and the 3 boys got nothing. So he said, what advice do you have for me? And our advice was, be very, very nice to your stepsister. Because in this instance, here he thought he was doing perhaps a prudent or frugal thing by avoiding the $1,000 or whatever it would have cost to get a will for he and his wife. He was saving big dollars. But what happened was, because they were killed in the same car accident, it really meant that his own 3 children ended up getting nothing of his estate. So this kind of thing happens all the time, and to suggest or think for a moment that you don't really have to get things done is a real foible approach. Major Vival's gifting. By that, I simply mean while you're alive, you decide to give away your assets. You're giving away your stuff. The problem with that is horrible things can happen. The question you have to ask yourself is this. If I give away all of my assets now to my kids, and I need the assets back, can I get the assets? The answer is no. Most people think, oh yes, I've got great kids. If I need the money back, I'll be able to get it. And I'm going to give you an example of what happened very close to here, probably about 25 to 30 years ago. There was a lady had amassed $1 million, and for 25 or 30 years ago, that was a ton of money. She had a son and a daughter. She had decided that she was going to give this money to her son and daughter and watch them build it even more. So against the advice of her advisor and against the advice of her lawyer, she gave the money to her son and her daughter. The problem was this. The son turned out to be a horrible spendthrift. He wasted the money. He went through it, he bought toys, he gambled, he did everything imaginable. He ended up with no money in a very short period of time. The daughter, though, was much wiser than the son. She paid off her mortgage, she put her kids through university, she retired from her work, life went on, and then all of a sudden the mom had a big stroke. And so that was just about the time that some of these new assisted living centers and nursing homes were popping up all over the place, and there was one just down the road from this particular lady, and she wanted to go there. It was going to be expensive, but some of her neighbors and buddies were already there, so that's where she wanted to go. So she went back to her son and said, son, I need my money back. He had to say, I'm sorry, I don't have it. So she went to the daughter and said, I need my money back. The daughter said, don't worry, Mom, I'm going to go to the bank, make some arrangements, we'll get you your money back. So now, though, that the poor daughter is now retired, she hoped at least to get a remortgage on her house or a loan to pay back the money that her mom had given her in the first place. The trouble is, she didn't qualify for it, so she had to go back and tell Mom, sorry, I can't give you your money back. So the unfortunate thing here, or long story turned short, is that the poor mom had to apply to the provincial intake program for nursing homes, and instead of going where she wanted to go, she ended up about 60 or 70 miles away in a nursing home and didn't know a soul there, and forever after she ruled the day where she had given all of her money away. Now, I'm not suggesting for a minute that you have to be Mr. Scrooge or Mrs. Scrooge, and I'll use an example. Let's say I've got two boys, and they're both living with very beautiful, wonderful ladies, and I suspect that one of these days the phone will ring and it'll be one of the boys saying, "Hey, we're madly in love, we've decided to get married, and we're going to buy our love nest and live happily ever after, and we would like you and Mom to contribute some money to our down payment for our love nest." Happens all the time. Usually then what happens is Mom and Dad dig out the checkbook and they write a check to Junior for 100 grand, and that's the end of the story. That's the not so smart way of helping out Junior in that example. Perhaps a smarter way to have actually done that same thing was, when he requests the money, yes, give him the check, but take back either a mortgage or a bona fide note, so that what happens typically is that 6 days or 6 months or 6 years after they've lived in lust in their love nest, she wakes up one morning and says, "I don't like you anymore and I'm leaving." And if you haven't got that mortgage or note in place, guess where half of that money is going? Out the door with the outgoing daughter-in-law. So a great way to protect that from the problem of a marriage breakdown is, when you give that money to your child, take back the mortgage or take back a note, so that if there's a marriage breakdown, there's not going to be an issue with that money walking out the door with the outgoing spouse. Joint registration or joint ownership. This is something I want to spend a fair bit of time on, because for 35 years now, this is by far the most widely abused or misused approach to estate planning. People think that holding an asset in joint names is the be-all and end-all of estate planning. Sometimes it is, but more seldom is that the case. So we're going to go through when it's good and when it's not so good. I'm going to pick on my wife. Let's say that my wife and I own all of our assets in joint names. So our house, our cottage, our non-registered investments, everything is held as myself and my wife jointly with right of survivorship. And then, boom, I pass away. The beauty of that approach is that immediately the ownership of those assets vests immediately, indefeasibly. It's basically hers. She doesn't have to go to probate. She doesn't have to consult with a lawyer. She doesn't need anything other than a funeral director's statement of death to provide to Pamela and say, "Here, change the name from Gary and Daphne to just Daphne." It's hers. There's no delay. She doesn't have to have the probate of the will. She doesn't have to incur probate tax. In Nova Scotia, you'll commonly hear of people saying, "I'm going to put everything in joint names solely to avoid probate tax, because probate tax is a gazillion %." Now, probate tax is quite expensive in Nova Scotia. In fact, here in Nova Scotia, we have the highest probate tax of any jurisdiction in the country. But does anyone have an idea of how much the actual probate tax is?
7%?
A lot of times people say 5, 7, 10, 20%. It's 1.695%. So you'll see people putting assets at risk to hold them in joint names simply to avoid paying a little bit of probate tax. Let's say in my own instance, my wife's great with money, I have no concerns, and I don't care when I'm dead and gone if she lines up with another chap and they live happily ever after. When I die, my intention is to give everything to my spouse. If that's the case, the holding of jointly held assets is a great idea. Now, I'm going to give you some circumstances though when it's not a great idea. And again, we're talking only between spouses here. We're going to get to the next level in a second. But between spouses, again, picking on my wife, let's pretend for a moment that I have a huge concern with my wife. She likes shoes way too much. So when I die, my fear is she's going to be the next Imelda Marco, and she's going to take my $1 million and blow it on shoes. And at the end of her day, then, there'll be nothing left to go to my two boys except a big pile of women's shoes. And my boys aren't really into women's shoes. So it's not a real good use of our inheritance to let mommy waste it that way. So for example, if my wife is a spendthrift, she likes shoes too much, perhaps holding my assets in joint names with her is not a great idea. There are some other options that we're going to chat about. Another more common concern these days, or more prevalent concern, is this. Let's say that when I've predeceased my wife, she's now a widow, we hold everything in joint names. We live next door to Mr. Muscles. Mr. Muscles jumps the fence, moves in with mommy, they live happily ever after on my $1 million. The end of the day, again, there's nothing left to go to my 2 boys. Or worse, perhaps my $1 million has gone to his family, not mine. That happens a lot. So if you are truly concerned that that could happen, and we're not simply talking about how it's going to benefit the surviving spouse, it's will that surviving spouse, who then inherits all these assets, pass the assets along to your children or your loved ones. So it's like chess, we're thinking 2 levels out here. So that is of huge concern, and if you do have that concern, you've got to have some soul searching and decide perhaps it's not a great idea to hold the assets in joint names, because 3 horrible things can often happen. I'll use again the example of my wife. She's conveyed all of the ownership to her assets in joint names with her and the 2 boys. What happens then when she sells the house, or upon her death she's deemed to have sold the house, is that CRA will now look at that and say, oh, aha, you don't own this house. There's 3 of you that own this house. Therefore, we are denying you the principal residence designation. In other words, you're not going to be able to claim that the capital gain on your house is tax-free, which otherwise would be the case. If we pass away, or if we've sold our house, and we're the sole owner of that house, or if we hold it between spouses, there's no capital gain involved, simply because the tax rules say that if it's your principal residence and you own the house, you don't have to worry about paying tax on the capital gain. But in the example I'm using now, where my wife and my 2 boys own the house, she is not the sole owner of that house, and CRA could deny her the use of the principal residence designation on at least 2/3 of the value of that house, and 2/3 of the capital gains. Most people don't realize that. So unintendedly, you could be making a huge tax mess by putting someone else's name on your property from the perspective of capital gains and the principal residence exemption. Another tax-related issue is this. The very minute that mommy has made her assets joint with the 2 boys, CRA deems that she has disposed of 2/3 of those assets. Capital gains come into play. And again, a lot of people don't realize that. They just change the registration and life goes on, and they hope that once they're told different, that Revenue Canada never catches up to them. But CRA is now starting to look at these kinds of transactions. So it's not generally a good idea to put the assets in joint names with anyone other than the spouse. I'm going to say that yet one more time. Here's another example. Again, unintended. But the minute that mommy has made her assets jointly with the 2 boys, non-tax-wise here at all, it has no tax impact for this concern, and this concern is even bigger than the tax problem that she created, and that is she's tied her cart to somebody else's horse. What happens if one of my boys goes through a bankruptcy? Or one of the boys has a huge financial claim placed upon him and his assets? Or one of the boys has a marriage breakdown? Chances are then that the trustee in bankruptcy or claimant or the outgoing spouse's lawyer is going to come and lay claim to the assets that are in joint names with that particular son. Now, is there a chance that my wife would lose those assets? It depends on what commingling, if any, there had been in those assets by my son. If there's been none, chances are that the claimant or the trustee in bankruptcy or the outgoing spouse would not be successful in making that claim. However, they're still going to make the claim, and my poor wife at that point is now 80, and she has to trot along into court to defend retention of her own assets. So things can really come off the rails fast when you're looking at holding assets in joint names with anyone other than a spouse. And one final time, in my opinion, it's not a good idea to hold your assets jointly with anyone other than your spouse. Now, I'm going to give you some circumstances though when it's not a great idea. And again, we're talking only between spouses here. We're going to get to the next level in a second. But between spouses, again, picking on my wife, let's pretend for a moment that I have a huge concern with my wife. She likes shoes way too much. So when I die, my fear is she's going to be the next Imelda Marco, and she's going to take my $1 million and blow it on shoes. And at the end of her day, then, there'll be nothing left to go to my 2 boys except a big pile of women's shoes. And my boys aren't really into women's shoes. So it's not a real good use of our inheritance to let mommy waste it that way. So for example, if my wife is a spendthrift, she likes shoes too much, perhaps holding my assets in joint names with her is not a great idea. There are some other options that we're going to chat about. Another more common concern these days, or more prevalent concern, is this. Let's say that when I've predeceased my wife, she's now a widow, we hold everything in joint names. We live next door to Mr. Muscles. Mr. Muscles jumps the fence, moves in with mommy, they live happily ever after on my $1 million. At the end of the day, again, there's nothing left to go to my 2 boys. Or worse, perhaps my $1 million has gone to his family, not mine. That happens a lot. So if you are truly concerned that that could happen, and we're not simply talking about how it's going to benefit the surviving spouse, it's will that surviving spouse, who then inherits all these assets, pass the assets along to your children or your loved ones. So it's like chess, we're thinking 2 levels out here. So that is of huge concern, and if you do have that concern, you've got to have some soul searching and decide perhaps it's not a great idea to hold the assets in joint names between myself and my spouse. Here's the case perhaps where you do not want to do that. And I'm going to go back and pick on my wife again. Let's say that I have the concern that she's a spendthrift, she likes shoes too much. Or let's say I'm concerned with Mr. Muscles jumping the fence. In either of those instances, if I leave her as the designated beneficiary on my plan, she then has the ability to collapse it and spend it on shoes or gift it to Mr. Muscles. I don't want that to happen. So perhaps, the whole taxation issue aside, perhaps what I might do is put her name for a third and each of my 2 boys designate as a third. I still avoid the probate tax and the whole probate system with that asset, and I'm ensured at least that something is going to go to my 2 boys. They're going to get 1/3 of the gross value of my RSP at death in that example. They don't have to pay tax on it. My estate has to pay tax on it. A lot of people, again, don't think that happens. They think that by giving someone money from an RSP that they're going to pay the tax on it. That's not what happens. It's the estate of the annuitant or the holder of the RSP that has to pay the tax. All of that amount that was in your RSP on the date of death goes on your final tax return. That's where it's taxed. Generally, the goods and the bads of holding the assets if there's a spouse. I guess the only pitfall is said there. If I choose to give it to my spouse or even to my boys as designated beneficiary, I then have no control over how it's looked after. In other words, upon my death, if I leave everything to my 2 boys, if one of them is a spendthrift, and one of them's pretty close to that definition in my instance, he's a great guy, he's got a great job, he's wonderful, and I love him to death, but if I leave him $1 million, it's going to do him far more harm than it would do him good. In 6 months, he'd have all kinds of new friends and toys and everything else, but he'd likely have no money left. So is it a good idea to go that approach? Perhaps not. The same could be said for anyone's spouse. I mean, it might not be a good idea to actually allow that money to roll simply because if they have a spendthrift tendency or would be taken advantage of by a Mr. Muscles, then it might not be a good idea to designate them as the beneficiary on that policy. Granted, you have to pay tax on that amount that you do not designate to your spouse, but having half of something at the end of the day where you've got some control over it might be better than having nothing at the end of the day where you have lost control. Anything that you have in your RSP or RIF,
Not calculated.
it's all taxable.
Yeah, that's right.
So the only time you're going to avoid tax on it is, in fact, you're not avoiding tax, you're deferring tax and assigning that a tax to your spouse if she is or he is the beneficiary. But if it goes, or any portion of it goes to a non-spouse, then that portion has to be tax included and tax paid within your final tax return. So if there's $100 grand there that you designate to your son, he's going to get the whole $100 grand. He doesn't pay tax on it. What happens is that $100 grand goes on your final tax return. right?
On the estate?
No, not the estate. The estate has a special tax return called the T3. When we pass away, we still have to do a final tax return for January 1 to the day we pass away. It's called our terminal T1 return. That's where your capital gains, that's where the value of RSPs that aren't flowing to a spouse would actually get put in place. So let's say if I die on December 1st, and my normal income, say, is 120 grand a year, boom, I've already got 100 grand in that I've got to report, which is my regular income up to December 1st. And then I've got, say, 300 or 400 grand in capital gains, half of which is taxable. So that has to be put on top of my 100 grand regular income. Then on top of that all again, my $200,000 or $300,000 RSP, if it's not going to my spouse, is put again on top of all that. So here in Nova Scotia, of course, then I could end up losing potentially more than half of that income out the door to the taxman. So a lot of the estate planning is a huge exercise in not only knowing the circumstances of your family and if there's any foibles in the kids and that kind of thing, but it's also an exercise in looking at how your assets are registered, where they're held, and looking at the whole tax piece as well, because you don't want to make Revenue Canada rich at the expense of anyone else. It's still a valuable tool, but still it's a huge sleeper for a lot of people that don't realize that when they die, if they've got, let's say, 500 grand in an RSP, somebody has to pay tax on that if it's not going to a spouse. Huge payday.
And so there's just a beneficiary named for a RIF, right?
Yes, and the beneficiary can be an individual, it can be your spouse or kids or whoever, it can be several individuals. You can even say, give it to my 2 boys, and if they're not around, give it to their children. So you can have alternate beneficiaries named or appointed. You can appoint your estate as a beneficiary. The advantage there with appointing the estate is that when I'm dead and gone, that money, all of it will come into my estate and be governed by the terms of my will. So if, for example, one of my boys is a spendthrift and I don't really want him to get his hands on all of this money immediately, I can establish something called a trust for him. So it's a great way to make certain that in a lot of people's minds, fair is equal, equal is fair, that I can control what goes to the 2 of them to the penny if it all comes into this one big bucket called my estate, and then decide how it goes from there. If you try to be, let's say, cute and say, well, I've got a $500,000 RSP and I've got the rest of my money is $500,000. I'm going to designate that RSP to one son, and then in my will I'll leave everything else to my other son. You might think, that's fair because it's equal. Each of them are going to get 500 grand. They're not. What's going to happen there is that the son who gets the RSP will get $500,000. The son who's the sole beneficiary of my estate first has to pay probate tax, executor, lawyer, tax on the money that's going to his brother. So that poor soul might only get 200 grand instead of 500 grand that went to the other brother. So you've got to be very careful how you design your estate plan to make certain it accomplishes what you want it to. So a lot of people, if they try to get cute or too complicated, they may end up shooting themselves or their family in the foot. So a lot of times, if you want to be careful about that, everything can actually be paid into the estate, so then your estate governs it thereafter to the penny as to what goes to each beneficiary. You can also do something that's kind of innovative, and it actually saves probate tax and other testamentary expenses, and it works like this. Let's say that I have an insurance policy or a very large RSP. When I die, normally you'd think, well, if I want to control everything, it's going to go into my estate. As it goes into my estate, it's going to be hit by probate tax and all these other horrible fees that everyone likes to get rich of. Is there another option? Yes, there's something in law called an insurance testamentary trust. And basically what it is in my will, I can create a trust for my kids, and then in the designation of my life insurance policy or my big RSP, instead of having that money paid into my estate, which would attract these fees, I can have the designated beneficiary be the trustee of the trusts that I've created in my will. What happens in that event is that the money will actually go around the estate instead of through it, and it'll go directly into the trust that I've established in my will for my 2 boys. So it's a great way to avoid the probate tax and lawyers' fees and everything else, and 100% of what is going will fund those trusts. So there is that capability that we have in looking at your will, but there are some some tax-related implications that we have to be concerned with when we do that. So essentially the moral here is that when you go that route, you've got to get sound advice from your estate planner. Don't sit down with estate planning for dummies and think that you can perform the surgery on yourself. Speak to someone who knows what they're doing. Make arrangements through Pamela to speak to me or your lawyer. A lot of lawyers too do not specialize in this kind of activity. So if they're a property lawyer, don't waste your time talking to them about estate matters. Talk to someone who actually specializes in drafting will and estate documents. Preferably somebody with a TEP designation or someone that has actual knowledge of this kind of event. Okay. Again, this is just reiterating the issue of the insurance testamentary trust that we just spoke of. It saves probate tax. It allows you to put some strings around the inheritance. So if you've got a spendthrift, or if you simply want to create some sort of a legacy for generations to come, you're able to do that within your will. Inter vivos trust, and inter vivos is just a Latin legal term for in the living. So it contemplates that while you're alive, you go see your lawyer, the lawyer will craft this document called a trust agreement, you sign it, and you then put all your assets in it. So at that point onward, the trust owns those assets, not you. And there's a couple of special kinds of inter vivos trust that we're going to chat about. The first one that some of you may have heard of is something called a family trust. A family trust has been very popular for years, and its intention is not so much to do things like estate planning or any benefit to it, but simply a lot of times when we use the term IV trust or inter vivos trust or living trust, this is the type of thing that people think of. And the predominant use of this is that, let's say I'm a business owner, and I am used to declaring all of the income from the business on my tax return. So it gets kind of expensive after a while, especially as the business and the income from the business goes like this. So there's all kinds of ways to take some tax advantage here, and for years one of the best approaches has been to use something called a family trust. What happens there is that my lawyer or my accountant with the lawyer would create this inter vivos trust or this family trust, and then the ownership of my shares would transfer from me to the family trust. So the family trust now owns the shares of my business. The income from my business goes into this family trust. But what happens, and this is where the tax advantage comes in, is that I'm not the only beneficiary of the family trust. It's a discretionary trust, which means that I, perhaps as the trustee, can say who amongst all this list of beneficiaries is going to get the income each year. So I've got my spouse in there, I've got my 4 kids in there, I've got my grandparents in there, whoever I want can actually be a beneficiary within this inter vivos trust or this family trust. So each year, if I'm getting all kinds of income going into this trust as earned by my business, instead of me having to declare income tax on it and pay 54% highest marginal tax rate in Nova Scotia, I can have the luxury of sitting there in December and say, okay, junior's in university, we're going to give him $80,000 because he's not going to pay very much tax on that. I'm going to give my wife $30,000, I'm going to give me $60,000. So I'm able to say who gets what amount of income from my business, and you save a ton of income tax through what we call income sprinkling. So a lot of people, when we talk about IV trusts or inter vivos trusts, this is what we think of. But this generally is not targeted specifically for estate planning. The one that is, and becoming quite popular here in Nova Scotia particularly, is something called an alter ego trust or a joint partner trust. It's still an inter vivos trust, and here's some rules around it. If you or your spouse is at least 65 years of age, you're allowed to create one of these, and it is very much an estate planning tool. The advantages are becoming quite significant, and in fact, up until the year end of 2015, you didn't hear much about these things because the other option of use for trust was something called a testamentary trust. We're going to talk about that still in a second. But it was far more advantageous from a tax perspective to establish a testamentary trust instead of using these inter vivos trusts. But now, as of the end of the year, the government has leveled that tax playing field so that they're taxed exactly the same way. There's no longer the huge tax advantage that there once was with testamentary trusts. So now a lot of the lawyers are recommending the use of these inter vivos trusts as an estate planning tool, and here's how it works. Once I'm 65, I go see my lawyer. I tell him I want an alter ego or joint partner trust. He creates this document, and again, I sign it and put my assets in it. So I personally no longer own those assets. I still control them because I'm the trustee, and while I'm alive, only I can be the beneficiary of this trust. I can still take money out of it, I can still put money into it, I can give it away, I can spend money, whatever I want. It's just that the big difference is that Gary Murray no longer owns that asset. It's owned by the Gary Murray IV Trust. Now here's where the advantages come into play. When I die, my alter ego trust that my lawyer has created mirrors the terms of my will. So if in my will I wanted to set up a trust for each of my boys, and I want to pay some money to the church, or whatever I want to do within my will, I'm able to do the same thing within my alter ego or joint partner trust. So when I die, there's no delay for probate. In fact, there's no probate required because the trust has already been set up, it's already running, and simply because I've died, the document will say when Gary dies, here's the replacement trustee, and here's what happens to the money. So it basically replaces my will at the point of my death. So when that happens, I've just avoided the whole process of probate. And I've just avoided probate tax. So for example, if I've got $1 million estate and I've set up one of these and I've put my $1 million in the alter ego trust and I've died, I've just saved my estate about $17,000 in Nova Scotia. So it's very easy to do the math. The lawyer does cost, but remember, the lawyer perhaps is going to charge you anyway when you update your will and your power of attorney and personal directive. So the lawyer fee, yes, it's another document, and they do charge a bit more for this document than they would a normal will, but it's not $17,000. So you can call your lawyer and say, I'm interested in this alter ego trust. What's it going to cost me to set it up? He'll say, well, there's the document, then we've got to do a deed for your house to put it in the trust. It's going to be $4,000. So then you can look at, well, my estate's $1 million, and I'm going to save $17,000, and it's going to cost me an extra $4,000 to do it. I like that math, I'm going to do it. But if I'm, let's say, 65, and I think I'm going to live another 40 years because my family is great long livers, perhaps I might not want to go that approach, simply because I might spend the $4,000 now, and then chance that in a year or 10 or whenever, the government might come back and say, oh, we're doing away with these alter ego trusts. If you've got one, you now have to put it back in your own name. So, you know, there is that risk, but they haven't touched that kind of approach yet. So it's quite easy to do the math around what's it going to cost me to set it up and how much am I going to save. And as well, not only are you going to save probate tax, but you may be saving executor commissions and lawyers' charges. Because remember that once this is set up, the lawyer's out of the picture. Whereas if you go the route of traditional will, when you pass away, the lawyer's coming back into the picture to get probate and do what needs to be done with the deed and sale of the house and so forth. So, you know, it might be a wash when you look at the overall legal expenses. But
is the executor out of the picture
yes.
also?
Yes.
A named executor?
Yes. Your will, if everything is done appropriately, your will becomes moot in that sense. So a lot of people say, well, good, this replaces my will. I don't need a will. But you still need a will, and here's why. Once I've set up this, let's say an alter ego trust for myself, and I've got everything in it. Life goes on, life is grand. Let's say a month before I die, my dear Aunt Bessie from Ireland, who I've never met, passes away and leaves me in her will $1 million. That $1 million is not yet in my alter ego trust. So when it gets paid, it's going to be paid to the estate of Gary Murray. So that money comes into my estate, and my will has to govern it. So I still need the will in place to look after those catch-all assets that are outside of the ownership of the alter ego trust in that example. Okay, my will. They can also get a copy of the list of assets that I own to date of death. It's called an inventory. Now, in my instance, my name's Gary Murray, and chances are nobody's going to be that interested in poor old Gary Murray's affairs. But let's say for a moment that my name is not Gary Murray. Let's say it's Gary Irving or Gary Sobey or Gary Trudeau or some well-known person, and I've got a gazillion billion dollars in my own name. When I die, my will has to be probated. And I'll bet that Frank Magazine or Nosy Neighbors or whomever will be lining up at the door of the probate court to actually get a copy of that will and the list of assets. So one advantage that you get with this IV trust approach is that once that is set up, that document or that trust is completely confidential. It's not subject to the probate rules. No one will know it exists other than CRA, you, the lawyer who's prepared it, and your beneficiaries and your successor trustee. So if you do have a concern with privacy and you don't want to risk your affairs that are within your will to be out there as public knowledge, then this is a good alternative approach for you to consider. A further thing that it does, and this is dependent on what province you're in, it has varying degrees of significance. But let's look first at Nova Scotia. If I die and I hold my assets in my own name and I have a traditional will approach. Now, I've already mentioned I've got 2 boys. Let's pretend for a moment, though, that I fathered a 3rd child when I was a teenager. And he's a bad dude. He's out there floating around out there somewhere. He's been in and out of prison. He's a drug addict. Whatever horrible thing you can think of, that's this black sheep. He's my 3rd child. And I have no contact with him. He and I never talk. And I just know he's out there somewhere. So when I do my estate planning and I instruct my lawyer to do a will, I'm naturally going to tell the lawyer, just benefit my 2 boys. Because really that's who I consider my family. I don't consider this black sheep part of my family. The problem with that is this. In Nova Scotia, we have legislation called the Testator's Family Maintenance Act. And it basically looks after 2 very special kinds of people, your spouse and your children. So if I decide in that example to disfavor one of my children, what happens upon my death, once my will gets probated, this black sheep can throw a petition through the courts to say, hey, my dad's died. He forgot all about me. He favored my 2 brothers but didn't give me a dime. And the unfortunate thing here in Nova Scotia is that that Testator's Family Maintenance Act allows a judge to set aside my will. In fact, it allows the judge to rewrite my will. So if I had a concern that, listen, I don't want my affairs to be challenged, then do I want to go the traditional approach of a will? Because my will in probate is impacted by some of these special pieces of legislation or family law acts in other provinces that gives certain close beneficiaries rights against my estate. So if, however, I've not gone the original will approach or traditional approach of using a will, and I own no assets, they're in the name of my alter ego trust when I've passed away, and they only benefit my 2 boys, not the 3rd child, then I've basically challenge-proofed my affairs. That 3rd child has no recourse against that alter ego trust because that legislation that I mentioned has no impact on this special trust, this intervivals trust. It does have a significant impact on my will, but absolutely no impact on the alter ego trust. So if I have that concern that I want to say probate, again, it's not a huge deal, it's 1.695%, or if I want things to be confidential, or to protect my will from being challenged by either my spouse or my kids, and that's, again, only if I haven't favored them with consideration, as the court puts it, then I might want to look at the use of an alter ego trust instead of the traditional will approach. What we call a simple will or outright distributable will. Basically it says something like this: upon my death, I leave everything to my spouse. If she's predeceased me, I leave everything to my 2 boys in equal shares. Boom, full stop. So it contemplates that when I die, my executor goes out, collects all my assets, pays all my bills, and then distributes the money. So if in that instance, though, I've got spendthrifts involved as beneficiaries, or if I've got some challenged beneficiaries, or if I've got some reasons to actually be concerned about perhaps the ability of my son to maintain the money, or that perhaps he might be taken advantage of by some harlot out there who targets him to marry and squander the money away, then perhaps I don't want to go this kind of approach where I create an immediately distributable estate. The beauty of it is, I suppose if there is one, it contemplates for an immediate beneficiary to get the money. But that can also be a negative, because if, let's say, one of my boys is a spendthrift, as I said earlier, the last thing I'd want to do in that instance is to provide him with a lot of money where it would do him more harm than good. And that is the use of a testamentary trust. In the historical sense, these were commonly used for challenged beneficiaries or children, say, that couldn't handle money. But for many years, I'd say the last 20 or 30 years, they were very commonly suggested simply to save income tax, because there was a huge benefit that, say, in Nova Scotia, through income splitting, you could save each of your beneficiaries up to $27,000 per year in income tax through the use of a testamentary trust. But as I said, as of this year, they've leveled that playing field so that you no longer have that huge tax advantage. There is still a way to do income sprinkling through the use of a testamentary trust, or any trust for that matter, and the way it works is this. My will might say, let's pretend for a moment that my wife has predeceased me. My will might say, upon my death, to divide my estate in half and create a trust for each of my two boys. It could then say that the income generated from this trust is to be paid to not only my son, but also to any of his children or his issue at the discretion of my trustee. So typically what would happen is that the income would be paid to my son, and he would spend it, use it, whatever. He has to put that income on his tax return. But let's say in any particular year, let's say one of his children is in university, and we all know how much that costs. So the child in university could actually earn, say, $30,000 or $40,000 and not pay a dime in income tax. So if in that scenario my will was smart enough to give the discretion to my trustees to actually pay to not only my son but to his children, then in that year the income can be paid directly to that child, and the taxation of that would go to the child, in which he'd pay little or no tax, instead of my son having to pay perhaps half of that out to the taxman. So there are still some great ways to, I won't say defeat the tax man, because you'll never beat the tax man, but it's a great way to actually sprinkle that income to beneficiaries who might have access to a lower marginal tax rate. So you can still use these trusts to benefit from a tax perspective in some way.
Stupid question.
Nope.
Does the kid actually get the money, or it just goes to his father and his father?
No, it would have to be paid directly to the child, or for the benefit of the child to the university or something. If the will, this is the worst case scenario, says, give it to my son and he can direct it the way he wants. If it says that, the son still has to declare all of the tax on it, because he then is in the position of making that decision. But if my will says that the trustees have the discretion to pay not only my son but any of his kids, then it's not him that's making that decision, it's the trustees. He could be a trustee, so he has a great degree of say in what's going on.
So the son still, the kid still gets some of that money put towards his university?
Yes. Yeah.
And the son gets whatever he gets from the trust?
Yeah. Yeah. And it can be established such that in normal years everything goes to the son. But there is that planning opportunity there to save some income tax. But let's say that, heaven forbid, down the road, one of my sons becomes physically infirm and he's disabled, and he's in a government-provided accommodation, and all of his benefits are income tested. So in other words, the more money he makes, the less money the government provides to him. You can still actually set up something called a Henson-style trust, where the trust money, where the income and capital is there, and then the trustee has the discretion of not only how much, but if anything, goes to the benefit of that child. So they're paying for things like his outings every weekend, his magazine subscriptions, his TV, all this kind of stuff, but it won't impact on what he's getting from other sources, because it's not something he is able to enforce payment. He has no vested interest in it. So there is, for anyone who has that kind of a scenario, there's still some ways to plan so that you can provide for a disabled beneficiary without impacting on what they are getting from government sources or income tested sources. One of the other main advantages with a testamentary trust is to use it in cases where there's blended families. And by that I mean, in fact, this is very common nowadays. Let's say I'll use my mom for example. Let's say that by the time my mom passes away, her will simply says, leave everything outright to Gary. And that's what might happen. Whereas if she leaves in a trust, and then the trust itself owns that money, and I have whatever degree of control or access to it that my mom has given me in her will, then I have a marriage breakdown, or if I have a problem with a bankruptcy or anything of that sort, the money that's in that trust is basically protected from any of those events. So if I have a marriage breakdown, it's a great way to ensure that that money that my mom wanted me to have is going to stay for my benefit and not half of it walk out the door with my outgoing spouse. So the use of the testamentary trust is a great way to make certain that the inheritance that you've left for your son or daughter is going to benefit only them in the instance of marriage breakdown or financial concerns or that kind of thing. Very common use as well in the sense of blended families. In the sense that, let's say I'm married a second time and we each have children of a former relationship. Typically, I would want at my death to actually benefit my spouse. I want to make certain that she doesn't do without, that if she needs income, then it's there for her. But I don't want to do that at the expense of someday passing my inheritance along to my two boys. So very commonly in that scenario, you'd set up a trust for my surviving spouse. She gets the income, and my trustees might have discretion that I grant them for medical emergencies or something of that sort, that they can encroach on the capital of trust for the benefit of my surviving widow. But beyond that, the money stays invested in the trust, and that upon her death, that capital goes to my children, not hers. So it's a very common approach to use the testamentary trust in cases of blended families. It ensures that the money is going to stay on your side of the family instead of going to the outlaws or in-laws. If you look at it this way, it's a way of someone putting in place a marital agreement for their beneficiaries. By that I mean this. Let's say that my mom is still alive, and for whatever reason she decides to make some changes in her estate plan. And she calls me on the phone and she says, Gary, I'm going to leave you $1 million, but only if you take this disclaimer document that my lawyer has prepared and get your wife to sign that, saying that upon my death that she'll never lay claim to this money that I'm going to leave you. Well, I then have to take that document and sneak around and explain to my wife, dear, you wouldn't want to sign this, would you? No, she wouldn't. And my love life thereafter would not be grand. But my mom can accomplish almost the same thing through the use of her will and a testamentary trust. She would leave my $1 million to be held in trust for me. I can have access to the income. She can give me whatever varying degree of access to capital that she would want as well. But what happens there is if I have, heaven forbid, a marriage breakdown, my wife can claim half of everything we own, but she can't touch the testamentary trust. So it's a great way of putting something in place that protects the inheritance for me alone against the likelihood of a marriage breakdown at some point down the road. So she's not upsetting my marital bliss, but it's a great way to make certain that the inheritance that she leaves is for my benefit and not my spouse's. Testamentary trust? Yes, this is an ordinary will. My will is an ordinary will, but instead of saying, upon my death I leave everything to my spouse, it would be, in that instance, upon my death I leave my money in trust for my spouse. She can draw on the income if she needs, or she can draw on capital if she needs it, and then it can go on to say, upon her death it goes to my two boys in equal shares. That's a testamentary trust. Still very popular for asset protection and protection against challenged beneficiaries, spendthrifts. So it's a very valuable planning tool. If you've got any significant size estate at all, I would encourage you to look deeply into the use of a testamentary trust. It depends on who you've appointed as your trustee. The question was, that's only set up upon your passing, which is right.
Yeah.
The will, the beauty of a will is that you can change it a million times between now and the day you die. Everything in it is moot. What's important is what's there on the day you pass away. So if that final will says that you're creating a testamentary trust for one of your beneficiaries or all of your beneficiaries, then that's what will happen at that point. If you've appointed a professional trustee, yes, they do charge an ongoing trustee fee. It's extremely little in the grand scheme of things. In fact, it's less in, let's say the instance here of our Gundy clients, less than 1% per year. In fact, it's entirely tax deductible if that trustee fee is paid to a professional trustee like CIBC Trust. And in that instance, it might work out to be 0.5% per year for all of the record keeping, all of that protection, all of that family refereeing, all of that things that a professional trustee has to do. So the fee involved should not be of concern or consequence. And in fact, if it is, you can actually instruct your lawyer to set it up such that sometime many moons down the road after the trust is set up and going, that you think maybe the children would have matured and learned what to do, say at age 50 or at age 60, that they can replace or dismiss the professional trustee, and that avoids that small penance of fees per year that's paid from the trust to the professional trustee. The only downside really of any testamentary trust is that for non-spousal testamentary trusts, every 21 years the tax authorities say that the assets that are in it are deemed to have been disposed of on that anniversary date. So that's the government's way of ensuring that I don't set up a trust that will go in perpetuity and I invest it all in growth stocks and they never then get to kick the can at that income. So every 21 years, the assets that are within a testamentary trust are deemed disposed of for tax purposes. Again, it's not a huge concern at all, particularly for a normal investment portfolio that doesn't have, say, shares of a family business that started off with an ACB of 0 and are now worth millions of dollars. But if you've got a traditional invested inheritance in a testamentary trust, then say at year 17, 18, 19, 20, the prudent trustee is going to look at the fact that at that 21st anniversary date, there's going to be a deemed disposition. So they're going to actually sell some every year to lessen that overall tax liability in the 21st year, to maintain or keep it below the lower marginal tax rates. And again, it's only the capital gains that we're talking about here, only half of which is taxable, not the entire capital. On the 7 topics or options that you have for estate planning, and I want to touch just for a bit on probate, the process, what's included, what isn't, and executors. Probate in Nova Scotia, you commonly will hear people trying to avoid it at all costs. It's not something to avoid at all costs. It is expensive, so on $1 million, it costs you almost $17,000, particularly if you look at other provinces. The same $1 million estate in PEI would cost you $4,000. The same estate in Alberta would cost you $400. So when you're talking to your MLA in Nova Scotia, we are taxed to death and beyond in a very high rate here. So we do pay quite high rate. What is included? Basically, when we die, anything in your name alone is going to be included in your inventory or your estate value for probate tax. So if I have a non-registered portfolio, if I have a registered portfolio where the designated beneficiary is my estate, all of that type of thing is included in my estate. If I have land that I own as tenants in common with my brother, then my interest in that property, and only my interest, would be included in the estate. So once you add all of that value up, they charge you a probate tax on it before they will grant you the letters of administration that allows your executor to proceed with the administration of your estate. Choosing an executor trustee. This is something that is most often overlooked from the perspective of significance, of importance. You spend perhaps lots of time thinking and stewing and brewing about how you're going to give your assets to your beneficiaries. And then you might think of, for 10 seconds or less, oh, we'll appoint our number 1 son or our number 1 daughter as the executor. Most people, unfortunately, still think of the role of the executor as something as an honor. It's no honor, believe me. If you ask anyone who has acted as an executor, the horns will come out and you'll often hear profanity and everything else, and they'll say they'll never do it again. So be very, very careful in your selection of who your executor might be. Couple of things that you should be very worried and think of. Firstly, the qualifications of a good executor. Have they ever done this before? Do they have the expertise to do it? Both my boys, one works for a large car dealership in Fort McMurray. He has trouble balancing his checkbook. My other boy in Lab City, he's a millwright. Great with his hands, but not so great in balancing his checkbook. So when I die, should I think, oh, well, I'm going to bestow that honor of executor to my two boys? Not a chance in heck. You know, I kind of look at it as well as when I retire, I want to build my dream home on the Northumberland Strait. And, you know, if I look at my two boys and think, who am I going to hire as my general contractor to build this house? I'm not even going to consider for a moment that I'd hire either of my two boys to do this. They don't live here. They've never built an outhouse before in their lives, let alone my dream house. So why would I consider appointing them as my general contractor to build my dream house? The estate is no different. People will look at an estate if they haven't administered one before, and they'll say, oh, we'll bestow that honor on our oldest son or oldest daughter. And they're putting a huge amount of grief, personal responsibility, and liability on that poor son or daughter's shoulders. And what commonly happens with estates, and as I say, I've been doing this for about 36 years, estates by far outweigh anything else out there that makes a family do this. They might get along great while mom and dad are alive, but you know, once there's an estate on the table and the family gets involved, the last thing you want to see happen is this. So ask yourself the question, are they competent enough to do the estate? Do they have the expertise? Do they have knowledge in taxes, in tax planning, in law, property management, all these things that we deal with, record keeping? And unless you're looking at someone that is perhaps a lawyer or accountant that practices in this stuff, the answer to that question is no, they don't have that expertise. You have to look at availability. Where are they? I mentioned that my two boys, one in Alberta, one in Lab. You think that I should appoint them to sit here in my house to make certain cells and look after everything? No. You've got to have somebody that's here. Availability is another respect as well. A lot of people will say, you know, I'm now 85 and I'm going to appoint my brother who is 86 as my executor. Chances are the poor brother is going to predecease you, or at least not be capable or available to do this. So you got to think of that as well. Not only are they around here, but will they be around when they're called upon to act? Third issue for an executor, are they able to be objective and trustworthy? So let's say you've got an instance where you've got 4 kids. Again, it's not fair to pick on 1 or 2 or whatever them, but whoever you appoint, do they have the ability to always be objective when it comes to their siblings? Perhaps not. You've got to have someone that does not have an axe to grind, or would not get into perhaps arguments or be anything less than objective and trustworthy when they're dealing with the estate. I mentioned the whole issue of family discord. People end up doing this when they're executors. People don't realize how much work's involved, how much time's involved. They're basically going to lose 3 years of their life. The rest of the family is going to hate them at the end of the day. So no wonder when people are asked that have done this before, would you ever do it again? No. So have the discussion. If you are set on appointing someone in your family as an executor, have the discussion with them. Ask them, have you ever done it before? Would you still want to do it? Have you the expertise to do it? Will you be around? No, I'm going to be on a beach in Fiji. Well, don't appoint her. So there are these things to consider when you're looking at executor, and nobody does. There was a lady in Ontario, lived in one of the big lakes up there, and had $1 million mansion. That's all she had in her estate. Anyway, she passed away. She had 4 kids, 1 son, the eldest, and then 3 daughters. This lady left a will, and in it, guess who she appointed? Number 1 son was her executor. Now, she died in March, February, whenever it was. Her son was a building contractor, had a very busy business, and he was busy, didn't get time to do an awful lot with mom's estate,
And 1 month led into 3 or 4 or 5, and all of a sudden one of his sisters calls him one day when he's at work, and he says, "Oh my soul, Mom's house is burning to the ground." Sure enough, the mom's house gets flattened. So there's the $1 million house, flat as a pancake, burnt. So he is just flabbergasted, and then he kind of smiles for a minute thinking, this is great. We're not going to fight over Mom's jewelry or her dishes. I'm simply going to call the insurance agent. We're going to file a claim, and we're going to get this big insurance check. We're going to divide it 4 ways. Everybody's going to go away happy. What a marvelous thing. Anyway, he calls the insurance company and says, "Mom's house burned down." "Well, where's Mom?" "Mom's dead." "When did she die?" "5 months ago." "Well, you didn't contact us." "No." He didn't realize it, but in the insurance policy, in every one of your homeowner's policies, this still is there today. I had my renewal the other day, and I looked just to see, sure enough, in very fine print, it says in there that if your property is vacant or unoccupied for a period of more than 30 days, you have an obligation to contact your agent or the insurance company, and they have the right to refuse insurance on it while it's vacant, or they can put what's called a vacancy permit on your house, which is much higher premium, much lower coverage, and it covers you while you're in Florida or wherever the case may be. But the big thing here is that if you don't do that, they will deny you coverage on the policy. So in this instance, when this chap, the executor, called the insurance company and said, "Mom's house is burnt down," they basically says, "Tough, you're not getting paid." So what happened? His 3 sisters sued him for the loss that he created. He lost his business and his own house to partially pay for the money that ought to have gone to his sisters. So again, thereafter, there wouldn't be much left between he and his sisters. So the moral of the story is people don't know what they don't know. And if you're going to put one of your kids in that predicament, make certain that they know that they have to be very knowledgeable, and make certain as well that if you appointed someone that they have the ability to make good on a loss that they may create. I don't want to put this burden on my family. What can I do? There are options. A very common approach these days is that someone within the family, say someone that's here, knows the family, knows the circumstances and the dynamics within it, and the trust company get appointed as co-executors of Mom and Dad's estate. So typically on the first to die, Mom and Dad would appoint each other as their executor. Then on the death of the survivor, they appoint Junior and the trust company as co-trustees. In law, the co-trustees have to do everything in unison. They're basically legally joined at the hip. But pragmatically what happens is the trust company does 99% of the work. Every decision though that's made, the individual co-executor or the family member has just as much say as the trust company. So it's a great way for a lot of people to gain the comfort knowing, well, Junior knows my thoughts, and he knows the family and everything else, but I don't want to burden him with all of this other mechanical and record keeping and everything else that has to happen. So in that sense, a good fit is the trust company, which is the professional executor trustee, and a family member. So that happens quite a bit.
Asia, how long does that process take if you have CIBC take care of your business and you die?
Less time than it would if you appointed one of the kids. Because if I appoint one of my boys, typically what happens is that he then goes out, does what? Hires a lawyer. The lawyer's going to do just the legal work. And then the lawyer's going to say, okay, here's some things for you to do. You go do it this month and come back and see me in 2 or 3 months. So the executor would go do that, come back 2 or 3 months, and something that should take maybe a year and a half is now going out to 3 and 4 years simply to get it all done. And the unfortunate thing is that at that point, not only does my son realize, oh my God, this was awful. Yeah, I want my 5% because I've gone through absolute horrible turmoil here. The problem is that for all of this babysitting that the law firm has done with my executor, their clock has been running ever since. So the legal bill for my estate is going to be much higher in that instance than if you've appointed the executor, the professional executor in the first place. Now, when we're involved, yes, we try to do it as quick as possible, but we don't do that at the expense of prudent planning. Now, as a result of one of the recent tax changes that's happened, an estate, once you pass away, can, for a period of up to 3 years, income split. In other words, I die and I leave $1 million in my estate. If my 2 boys don't need that $1 million or the income from it right away, they would be wise to leave it in my estate, leave it invested, because my estate, for up to 3 years, it's called a GREE or graduated rate estate, can actually pay the tax at a lower marginal tax rate than my 2 boys. So for up to 3 years after I've passed away, it's a great way to gain some nice income splitting to save thousands of dollars to my 2 boys. So when we get involved, we have this discussion and this planning that goes on with the beneficiaries to say, does this make sense? Are we going to go this approach? So we do all of that planning with and for them so that they may say, yeah, take this out as long as you can. So it might be that the estate, because of their wishes, will go for 3 or 4 years. Or it might be that, there's not enough to worry, they need the money right away, let's get this wound up, and it's done within 1.5 years, maybe a little more. The problem with estates taking a long time in the past number of years is not that your executor is slow or uneducated or anything of that sort. It's to deal with CRA or Revenue Canada. Historically, once all of the tax work has been done and notices of assessments have been gained by the executor has to file for something called a clearance certificate from CRA. Historically, they would do that in 4 or 5, 6 months. Now they're taking a year or 18 months to issue that clearance certificate. So that's the reason that you'll commonly hear now a lot of times when people are complaining that, oh yeah, we had Grampy's estate and it took us 2.5 years to get it wound up. Well, that doesn't mean that the money is frozen for 2.5 years. In that instant, quite commonly after 6 months, there's a huge advance paid to the beneficiaries, and then a small balance is retained until they get the clearance certificate. So, not quick and easy answers to any of those questions, but still something that when you're getting a professional involved, all of this is a learning experience for the family, and the estate should be administered to the betterment of the family and the beneficiaries.
Yeah.
The unfortunate thing with CRA is that if you want the clearance certificate, you have to be willing to wait. And with governments over the years, they were able to hit the public sector, and where perhaps there may have been 1,000 auditors at CRA, maybe now there's only 300.
Yeah.
See, now they're going to put a bunch more back in there. But it depends on their resources, the flood of estates coming in. And remember that the population is getting older, so there's many, many more requests for clearances now than there was, say, 30, 40 years ago.
Yeah. But then an executor would sort of have to hang on to some money, right?
Yes, indeed. There's a very good point. Yes, if an executor takes the risk of spending out or distributing all of the assets before he or she gets that clearance certificate, and then before the clearance certificate is issued, CRA comes back and says, oh, the estate owes us $100,000 and here's why. Guess who's on the hook for the payment of that $100,000? The executor. So there's a personal liability that's attached to the executor for what they have paid out in distribution if that money is not available to pay the tax bill prior to the receipt of the clearance certificate. Really good question.
And that clearance certificate protects you. The
Yes.
CRA cannot come back to you after for
As
any
executor,
land or
that's correct.
real or personal.
That's right. Yeah, they can't come back on you as
7
the
years
executor.
later and say,
No.
I don't think you paid
You can
enough
do
capital
this,
gains.
but if you're the beneficiary, they have the ability to trace assets. So if you were the executor, they can't come back under your role as
Oh,
executor.
on executor, okay, what about
But
the
if
owner?
you were a beneficiary, yes, they still have
Still
the ability
can?
to
After
trace
7 years?
assets. Yes.
8 years.
Now, 7 or 8 years, they're not going to have tax files anymore. Your last will and testament. What should be in it? As you can see, there's quite a list there, selection of executors, who gets your stuff, when and how, the inclusion of trusts. One thing I'm not a big fan of putting in your will is funeral instructions. Quite often, person passes away and the family doesn't dig out the will until after the funeral, after the wake, after the burial, or that kind of thing. So, if you put in your will, when I die, I want my remains donated to Dalhousie because I want to go back to college. But what happens then is at death, my family deals with my executor, my estate, and everything to do with my burial, they're going to have me buried or cremated and I'll put in the family plot and that's it. And then a week later, they dig up the will to say, oops, Dad wanted to go to university. It's too late then. So I'm not a fan of doing that. One of the things when we have a chat with our clients is that we deal with not only the will and the estate planning, as we now have done here, we deal with power of attorneys, personal directives, 2 other documents that very quickly I'm going to touch on in a second. But the fourth thing is the planning for your burial or your cremation or your funeral. Make certain that your loved ones know what your wishes are. Because if you tell no one and you pass away, your kids could go through proper turmoil for years afterwards, wondering if they did what mom or dad would have wanted. So I encourage you to have that discussion. You can actually prearrange and prepay and everything else through your funeral director. You don't have to do that, but at least tell your loved ones what your wishes are so that when you pass away, they have the option of respecting your wishes or saying, the heck with you, you're going in a bottle in the backyard. It's up to them at that point. But if they don't know what you want, they actually may worry for years afterwards if they did the right thing by mom or dad. Leaving the whole death or dying thing for a moment. Very commonly, as I said, when we chat with our clients, we end up helping them put in place not only a new will, but a power of attorney, an enduring power of attorney, which basically says that if I become incompetent or if I'm away or for whatever reason, I appoint this person, or the trust company to be my attorney to deal with my assets just as I now can. So if I'm appointed, let's say if I appoint my son as my attorney and I'm gone away to Florida for 6 months vacation, I could come back, my house could be sold. So make certain that the person you appoint is someone that not only knows what they're doing, but someone that you can trust implicitly, because they have huge power under the power of attorney to do whatever you can do now. Most attorneys are written that way and that they're non-restrictive, which means they can do with your assets anything they want. I'm a big fan of appointing, let's say, more than one in your power of attorney. So if you're going to appoint family members, appoint 2. One acts as a watchdog over the other, because there's no real sort of enforcement agency out there that looks at a power of attorney or the attorney's role in it and says you've done a good job or not. So very often when you see things in court fighting over someone's affairs, it's probably an attorney who's not done what they're supposed to do. If you have any reservations at all about who you're going to appoint, you should also consider appointing the trust company. That's something else that we do act as attorneys and people's POAs. A POA is something that's good to have simply because if I don't have one and I have a stroke, say, and I have to go to a nursing home and I'm no longer capable of managing my affairs, what happens there is that someone has to step up to the plate, apply to the court to be appointed as my guardian or my committee to actually look after my financial affairs, pay my income tax, my power bills, all that kind of thing. That whole process has delays in it. So that could take 6, 8, 10 months. And in the meantime, whoever I have in debt with and payments to are getting fairly anxious to get paid. It's very expensive as well. Here in Nova Scotia, it involves two doctors and the court's time, again, lawyers. So it's going to be $4,000 or $5,000, maybe $6,000 to have someone appointed as a committee or a guardian of the estate. So when you're doing your will, it's a great time to get a power of attorney done, and they don't charge a heck of a lot more for the inclusion of the power of attorney, simply because they have most of the power of attorneys all are identical. Mine would look the same as yours, whereas wills are totally different.
So your power of attorney have thorough power over your financial, say your bank account, so you can go in and pull out your bank account without his name being joint on it?
Yes, in fact, you should never, ever, ever contemplate putting an asset joint with someone just so that they have sort of quasi power of attorney role or powers over that asset. Leave the asset in your name alone, So there's never any dispute over what your intentions are with respect to that asset. And then your power of attorney that you have appointed, they have the power to deal with the banks, the brokers, the insurance companies, CRA, anyone with this document that you've given them, but they're acting on your assets. They have it's a fiduciary relationship really. They have to do what's best for you, not them. So that's again another reason why I like to see attorneys with 2 named people in it instead of 1, because if you just appoint one of your children or a nephew, who's there watching what they're doing? There's no disclosure requirements. There's nothing in the rules that say that I'd have to give everybody involved a statement every month or quarter. So this is a very dangerous role that you've got to be very concerned with, particularly with the selection of who you're going to appoint as your attorney under your POA. But again, it's just to deal with your stuff. He's got no, or she's got no ability to say what's going to happen with your person or your medical attention, or they're not responsible to see that you're fed and clothed. That's something else. But they are responsible to make certain your bills are paid, your taxes are up to date, your insurance is on your house, everything's maintained, protected. Historically, a lot of people refer to this as a living will or a medical substitution or a medical proxy, but since about 5 years now, the government has come out with legislation that allows you to create a document that does a couple of great things. Firstly, for those of us who have a very strong opinion as to what they want to happen in cases, let's say I'm in a horrible car accident and I'm laying on the gurney in the emergency ward and I'm ripped open because of this car accident, and perhaps I'm going to be in a coma for the next 20 years. The last thing I would want them to do is plug me into one of these life-sustaining pieces of machinery to keep me alive. So I now can actually state in much more eloquent terms than I've just stated, in writing, what my wishes are in that kind of a circumstance. So I'm able to say, if I'm in an accident and I'm never going to recover, please provide me with morphine and put a smile on my face and let me go. That's something that to this point, say 5 years ago, was not something that was very prominent in the province because there was no legislative bite behind it. Now there is. So the doctors actually are protected now when they act on the instructions for the person that you appoint in this document. This document is called a personal directive. The person that you appoint with the authority under the document is called your delegate. So the person that you appoint, and it has to be a person here. It cannot be the trust company. The law gives me lots of power, but they don't give me the power to pull someone's blood. You're actually able to provide someone with the power to do just that in your personal directive. So you're able to be very detailed in your wishes. That person, in addition to obviously having to respect your wishes, also has the power or the authority to deal with anything related to your health and welfare. In other words, they're the ones that are to take you to the doctor. They're the ones to decide what nursing home you reside in. They're the ones that make certain you're fed and clothed. So it's a very responsible position. It's got nothing to do with your assets or your stuff. It's to do with your personal well-being. You can only appoint one person at a time, but you can appoint an alternate. The reason for that is the doctors don't want to deal with 2 or 3 different people at a time. And I would encourage you, just as we chatted about with an executive role or power of attorney role, this role is even more important. Have the discussion with the person you have in mind to make certain they're okay with this. Another little story or example. Years ago when this first came out, I had a chat with my mom about this. Now, my mom has 4 kids. I'm the oldest, and there's 2 other boys. One lives down in the States, one lives in Liverpool. My youngest sister lives in Truro, and my mom's in Truro. So every day for lunch, my sister toddles on up the hill and has lunch with my mom. She can tell you what drugs she's on. She can tell you what she had for lunch every day this week. So my sister is very knowledgeable and involved with my mom's care. So when we had this discussion with my mom says naturally, oh, well, I'll appoint your sister as my delegate to do what needs to be done here. And my mom had some normal suggestions to put in this, like, for example, if I have a stroke and I'm not going to recover and I don't want you to keep me alive, unnecessarily. So we had that discussion then with my sister to say, would you be willing to act? And when my dad died, my sister had a very tough time. And so because of that, when we had this discussion with my sister, there was absolutely no way that she would be able to instruct the doctors to pull the plug. My sister, the big teardrops started coming, and there was no way that she could take that on herself. So my mom then had to make that decision of who else she would appoint. So have those discussions with the people you have in mind of appointing, whether it's executive or attorney or the delegate under your personal directive, so that they know what they're getting in for and they're agreeing to the ride that you're about to put them on.
Who has the money directive in that? The personal directive taking care of that person?
No, remember the personal directive gives power to deal with your personal health and welfare only. It's got nothing to do with your money or your stuff. That's your power of attorney. Sometimes it's the same person.
So they have to be connected.
Yeah.
The directive has to come to the other person
attorney
and say,
to
I
say-
want money to put her in this nursing home.
Exactly. I had a chat with my mom about this. Now, my mom has 4 kids. I'm the oldest, and there's 2 other boys. One lives down in the States, one lives in Liverpool. My youngest sister lives in Truro, and my mom's in Truro. So every day for lunch, my sister toddles on up the hill and has lunch with my mom. She can tell you what drug she's on. She can tell you what she had for lunch every day this week. So my sister is very knowledgeable and involved with my mom's care. So when we had this discussion with my mom says naturally, oh, well, I'll appoint your sister as my delegate to do what needs to be done here. And my mom had some normal suggestions to put in this, like, for example, if I have a stroke and I'm not going to recover and I don't want you to keep me alive unnecessarily. So we had that discussion then with my sister to say, would you be willing to act? And when my dad died, my sister had a very tough time. And so because of that, when we had this discussion with my sister, there was absolutely no way that she would be able to instruct the doctors to pull the plug. My sister, the big teardrops started coming, and there was no way that she could take that on herself. So my mom then had to make that decision of who else she would appoint. So have those discussions with the people you have in mind of appointing, whether it's executive or attorney or the delegate under your personal directive, so that they know what they're getting in for and they're agreeing to the ride that you're about to put them on.
Who has the money directive in that? The personal directive taking care of that person?
No, remember the personal directive gives power to deal with your personal health and welfare only. It's got nothing to do with your money or your stuff. That's your power of attorney. Sometimes it's the same person.
So they have to be connected.
Yeah.
The directive has to come to the other person
attorney
and
to
say, I
say-
want money to put her in this nursing home.
Exactly. A complete estate plan, as we mentioned, very commonly we'll start with your will, and we end up talking about trusts, we talk about the power of attorneys, we talk about the personal directive. Big thing is though, when you do this, make an inventory of your assets. I'm astounded, in fact I bet Craig is too, anytime that we do planning for our clients, most commonly the clients before they go through the planning will say, I've got a pretty simple estate, I don't have many assets, I'm not a wealthy person. But after we've gone through the plan and we make the client realize, did you know you're worth $2.1 million? Their mouth drops to the floor. People don't realize what they have, so it's important to know what wealth you have, where it's registered, how it's registered, where it's located, and then sit down and look at your beneficiaries, how you would want to benefit them, when, whether there's trusts involved, those kinds of things. And we can help with that kind of decision making. We can give you some information. Executive appointments, attorneys, very, very important. Once you decide on what you want, commonly we can help you as well. Interact with your lawyer. Very commonly I end up helping with the instructions to your lawyer. We kind of put things in sort of semi-legalese and deal with that first with you and then convey that information to your lawyer. The lawyer then prepares drafts of documents, sends it back to us so that you're getting multiple sets of eyes looking at it to make certain that it really represents what you should have and what you do want. because commonly, once a lawyer drafts documents, you see all of this legally goop that's thrown in front of you, and a document that thick, we're all guilty of not reading that or not understanding that. So it's our role to help you through that process. So Pamela's great at doing that. In fact, she's heard this spiel so many times, I'm sure she could do it herself. Reviewing it periodically. Make certain that once these documents get done, you don't just throw them in the safe deposit box or leave them with the lawyer and forget about them. Our circumstances change. We get new beneficiaries, or our assets change, those kinds of things. Make certain that all that is looked after at the same time.
Thank you for watching our 7 strategies for estate planning with our partner Gary Murray of CIBC Trust. As you can see, the process of estate planning is very important to my practice. So important that I produced this educational video to ensure that all my clients at the Chisholm Advisory Group can enjoy the video at their convenience. We encourage our clients to have the money talk with their loved ones, and this can begin by sharing this video link. The instructions to share are simple. If you need assistance, we would be happy to help. Our estate planning workshop often raises many questions. Our recommended next steps include having your will, power of attorney, and health directive reviewed. We can arrange to have a review of your estate planning needs wherever you live. Please click on the link below to request an estate review. If you do not have a will in place, we can begin by starting with a checklist to collect the information you need to establish the peace of mind a comprehensive estate and financial plan can ensure. Click on the link below or request our estate planning checklist and any other material you may wish. We hope you've enjoyed this video from the Chisholm Advisory Group, and we look forward to our financial planning video coming soon.